to Legally Speaking, with me, Tarun Nangia. Today we embark on a special two-part series on a very, very important issue that not only concerns the liberty of an individual, but it also concerns the confidence of the business community of India to invest in this country. It also concerns the confidence of the business community to commit funds to this country, because this issue concerns whether a person can be kept in jail, can be arrested post filing of charge sheet. Now, why did I give this introduction? Because in many cases we have seen that businessmen who are held for alleged financial crimes are being kept in jail even after filing of charge sheet. Now, how does this stand the scrutiny of law? That is what our eminent panel today, who are some of India's finest lawyers, they are going to discuss and share with us today. Also, the observations of Supreme Court of India on this issue. Also, how the courts have been conducting themselves with regards to liberty and arrest and, keeping people in judicial custody post filing of charge sheet. First, I'll introduce you to my panel. I have with me Senior Advocate Vikas Pava, who joins us after a long time. Welcome, Mr. Pava, and good to see you again.
Thank you.
I have with me Senior Advocate Pramod Kumar Dubey. Good to see you, Mr. Dubey. We saw you recently on the money laundering show where we had the opportunity to hear your interesting interventions. Good to see you again. I have with me Nitesh Rana, Advocate Nitesh Rana. As you all know, Mr. Nitesh Rana has been arguing these kind of matters in various states across the country. We look forward to having a good perspective from him, and welcome on Legally Speaking for the first time. And I hope it's not your last. We will get to see you more often. May I also welcome Advocate Tanveer Ahmed Mir, who also joins us on the first time. A very well-known name at the bar. You see him arguing many leading matters. Also a lot of enforcement directorate related matters. Mr. Mir, it is a pleasure to have you first time on the show.
Tarun, the pleasure is mutual, and it is an honor and privilege to join this show with you and my elder brother Vikas Pava and all my friends. And let me tell you, Mr. Nitesh Rana doesn't argue money laundering only locally. He does it internationally as well.
Okay. Point taken. May I also welcome Advocate Abhimanyu Bhandari. You saw his very, very interesting 2-minute takedown, where he advocated scrapping down of the money laundering law in the last episode, which was a very different take from the others. Welcome, Mr. Bhandari, on the show, and looking forward, as usual, to some interesting and different takes from your end, even on this issue. You happen to also argue, in addition to the Delhi High Court and the Supreme Court, other high courts in the country as well. Would like to know from you what is happening in these kind of cases there and the conduct of the courts in various parts of the country. May I now request Senior Advocate Vikas Pava to lay the ground of the show in about 2 minutes about what is happening in Delhi, what is also happening in the states, why are people and businessmen being held in jail post filing of charge sheet.
Thank you, Tarun. I think your topic today is very, very specific. We are not talking about bail in general or arrest in general. We are talking about cases where police chooses not to arrest the accused person during investigation, and they submit charge sheet in the court once investigation is concluded. And either they call the accused persons to the court that we are submitting the charge sheet, please reach there, or they leave it to the jurisdiction of the court, and the court ultimately issues summons to the accused persons to come and face the trial. Now, in these cases, earlier, it used to happen. I remember arguing a case with my friend, Mr. Rana, on the other side, when the charge sheet is filed without arrest and we appear in the court post summons and we file the bail application. And I asked my friend outside the court, are you opposing the bail? And he said, yes, of course we are opposing. So both of us go inside and we wait for the judge to come. And when the judge comes, and she's a lady in Rouse Avenue Court, She immediately comes out and says, bail application, post charge sheet, two sureties, 50,000 each. And we started looking at each other, that I've not even uttered a single line and the bail is granted. But those were the days when the law laid down by Justice J.D. Kapoor was prevailing. That was 2004, where he says if the arrest is not made during the investigation and charge sheet is filed, the bail, should be accepted by the court. Now things have changed. Why we are discussing this topic today is things have changed. Even when the accused are being called in the trial, they are forced to now file a comprehensive bail application. Bail applications are argued for months. Tarun, you'll be surprised. In few cases recently, which we have argued, some high-profile cases, bail applications are being argued for 6 months, and bail orders are running into 100 pages. These judgments which are cited by all the counsels are running into, say, about 70 judgments on bail. We don't need to file 70 judgments on bail. So things have changed. The Honorable Supreme Court is trying to streamline. But before I end my opening remark, my personal view is that instead of streamlining, I feel that it has become, more complicated. And this is across, it's not only in Delhi, I'm talking about outside Delhi also. So these few judgments which have been passed by the Supreme Court recently in the month of August, September, and October, according to my understanding, has not developed the jurisprudence of bail much, but on the contrary, has complicated more.
Okay. A very interesting setting the, in a sense, base comment for our introduction of this show. I'll go to Senior Advocate Pramod Kumar Dubey at this point. Mr. Dubey, I have seen you arguing not only in Delhi, sometimes in Lucknow, sometimes in other states. And it would not be unusual for me to comment when you say that there is a marked difference in how court treats bail. In when you argue in, say, the Delhi courts and the Supreme Court compared with other courts. Can you share your experience in your introductory comment? What is this difference that you see?
Thank you, Tarun. First, I would like to mention, as it is rightly been mentioned by my colleague, Mr. Vikas Pava, there is a judgment of J.D. Kapoor. And just it is a coincidence, that's a court on its own motion first. That is the J.D. Kapoor judgment, Justice J.D. Kapoor judgment in 2004. Then the court on court's motion is number 2, and number 3 is the Siddharth versus State of UP. And I would say just it's a coincidence. I'm basically represented the accused person in all the 3 cases. The first case, the Rajeshwar single matters, when the Delhi court gave the direction to the CBI, charge sheet will not be accepted unless and until you produce the accused in the custody. Then the law was laid down by Delhi High Court, and that law was prevailing. There was one incident when one of my clients went inside after the filing the charge sheet, and that's the Tajinder Singh versus CBI. I was also the part of that matter. Then the second court on its own motion came, and I was the amicus in that matter. That was the reference by the one of the judicial officer from the lower judiciary, and Justice Bipin Sani and Justice P.S. Teddy reiterated the view taken by Justice J.D. Kapoor by giving the finding the court on its own motion first is a good law. Then the Siddharth versus State of UP came in the Supreme Court, where the charge sheet was prepared, it was about to file, and the warrant was issued to arrest the person, and Justice S.K. Kaul settled the law by saying if the accused has not been arrested during the course of investigation, so he could not be arrested for the purpose of the filing the charge sheet or the post filing the charge sheet. The controversy came in the Satinder Kumar entail. Satinder Kumar entail, the guidelines were framed and so many things. Then the clarification was made. There's a section 45(2) is basically declared unconstitutional, and another bench is dealing with the matter, which is going on. And Abhimanyu is on his legs. I think he's going to complete his argument tomorrow. So, and in Satinder Kumar until while making the clarification, the Supreme Court Justice Sanjay Kishan Kaul reiterated the view taken by Supreme Court in Siddharth versus State of UP. So far as the Delhi is concerned, I find we have come across very few cases where the accused has been taken into custody after filing the charge sheet. Though there is a lengthy argument which has been mentioned by Mr. Pahwa and by the both sides, but the judges in Delhi High Court more or less following the court on its motion and Siddhartha state of UP. But unlike Delhi, like the UP and the other states, there is basically the general norm. Whether the charge sheet is filed, accused has been arrested or not, upon the filing the charge sheet, the court will take the cognizance, issue the process, whether it's a summon or warrant. Whenever the accused will appear, they will be taken into custody. So it's a very unusual practice in other states like the Madhya Pradesh and the other state we have come across. And there is a
so Mr. Dubey, you're saying it's not limited to UP, it's in all other states also.
Other states also there is a general practice to take the accused in the custody. That's why Justice Call took the cognizance of all this matter and laid down the law in the Siddhartha state of UP. So Siddhartha state of UP has given a lot of clarification, but still law needs more clarification and evaluation on this aspect. I don't think the accused should be taken into custody unless and until there is a arrest in the rare circumstances.
Point well taken. Go to Mr. Abhimanyu Bhandari. Mr. Bhandari, last time you gave a very strong argument on liberty. That 2.5 minutes, I think, was the longest. In this matter also, it is about liberty. Why to hold people in jail after filing of charge sheet? How would you view this? Also, can you give me a comparative example between UK and India? You practiced there earlier. What is the difference in terms of how we look at financial criminals?
Thanks, Tarun. I'll take your second point first. I think we spend a lot of time on bails, whether it is anticipatory bail, whether it is bail pre-filing of charge sheet or post-filing of charge sheet or an arrest before charge sheet is filed. And I think bails go on and on. And as you know, senior advocate Mr. Pahwa said that, for months he's argued certain bail applications, or he's seen certain bail applications being argued for weeks and days on. So we as a jurisdiction spend a lot of time on bail, and this whole system now needs to change. We are just spending too much time, and less time is being and less resources is being diverted in actually doing the trial. In other jurisdictions, bail is just taken for granted. You go, most of the time, the police officer will grant you bail. You go to a magistrate's court, and within 6 to 7 minutes, the bail hearing completes, and you are in 9 out of 10 cases granted bail. Even if there is a flight risk, they nowadays in all jurisdictions put what is called a bracelet, which works with the GPRS to ensure that the person can't escape the jurisdiction of the court. And therefore, they ensure that there is no threat to people going out. So they grant you bail, but the trial also there ends within a period of time, maximum 2 years' time. So no one sees that someone has to be taken custody. Here we are doing, whether it's a civil matter or it's a criminal matter, we all fight on interims. So I would say that the classic case of interim is that, you put the person behind bar because you feel that, listen, he's done something wrong and the trial will take a lot of time. So let's punish him for some time. So that whole philosophy has to now break down, and we have to start treating bail as a very normal procedural matter, whether it's pre or post filing of charge sheet. But yes.
So you say that clear distinction between how UK sees it and how India sees it.
Yes. And not only UK, how US sees it, how European countries see it. There is, Australia, I'm sorry, if you look at the jurisprudence that is coming from Australia, bail has just become a fundamental right. And till you're convicted by a court of law, there is no reason to keep you behind bars unless there is a high probability that you will commit that crime while you're outside. And therefore, so if it's a serial murderer who's committed 6 murders and you're not going to let him go because he's going to go out and again commit a crime, you keep him behind bars. But, in economic offenses where things are all transaction based, I don't see why we as a nation's jurisdiction spend so much time on bail, because we've started kind of thinking, every economic offense involves money. There is this whole narrative that the trial will take long. So therefore, there is some kind of a feeling that, okay, let him be in for some time. And I think that's a kind of a way of thinking that should break down. Now, of course, other panelists have told you that, now with court on its own motion decision of Delhi High Court, has clearly said that, once charge sheet is filed, and if the investigating officer took the decision not to arrest you while investigation is going on, there should not really be any reason to arrest you after filing of charge sheet. But that's fine. All that is okay. I want to ask a very fundamental question, and I think you should ask this to such a great panel that you have here today. Why should a public prosecutor oppose a bail application? Why did Mr. Pava that day walk in court, and why did Mr. Nitish Rana for the first time said, I'm going to oppose it? I mean, come on, why should a public prosecutor not apply his independent mind and say, I'm sorry, in this case, I'm not going to oppose? So I have a question for Mr. Nitish Rana, that how does he decide when to oppose, doesn't oppose? And do we, with such an eminent panel here of such great criminal jurists, why public prosecutors always have to oppose a bail application? Can't they have their own independence to think that, oh, I'm not going to oppose this, even if my client is going to, because as a public
Mr. Bhandari,
I have a bigger role.
If I may suggest, we will take this particular last statement topic on some other show.
Sure.
Today, we'll just proceed with the topic which we have at hand, which is arrest post charge sheet. The PP thing we can take on some other show, some other day, definitely. So I'll go to Mr. Nitesh Rana at this point. Now, I know you argue matters not only in Delhi, but in Jharkhand and other states. What marked difference have you seen in the approach of the courts towards liberty? Why is it different? Does Supreme Court, has it given any guidelines which are being violated because of people being kept in jail post charge sheet? And finally, could you share with us, is this tantamount to punishing people who are not guilty? Because you never know whether they'll be proven guilty. Is it in that sense a violation of human rights, just keeping people behind jail? Give me a full takedown on this.
I'll thank you so much, Tarun, for having me here, and my obeisance to everyone, all eminent panelists over here. And Abhimanyu, you're a good lawyer, and I'll answer your question some other time. We are here for a general discussion on the pre-arrest, pre-trial arrest, and the subsequent bail and all. So let's understand there are two fundamentals of the criminal law. When charge sheet comes to the court, there are two types of accused. One who are arrested during the investigation. Another, there's a column which is written not arrested during the investigation. Now today we are here for a specific, also those accused who are not arrested during investigation, not for those accused who are arrested during investigation, but after filing a charge sheet, whether bail has granted him or not, whether it should be granted him or not. So right now we are on the issue of those accused who are not arrested during the investigation, and whether he should be granted bail on the first occasion, or there should be argument over this. See, I as a lawyer, I always advocate personal liberty is the most precious gift we have got from the Constitution, and I always respect, and I see the situation maybe a couple of months or maybe a year before. So, situation of the law was little different when all the judgments of Satyendra Kumar Antil, Siddharth, or Amanpreet Singh, Inder Mohan Goswami, all the judgments came afterwards, 2020 onwards, when things were little clear about the law. I would rather little disagree with Mr. Pava and Mr. Dubey. The law still has to develop. I believe Supreme Court has given a sufficient law. What we have to do, what court, rest of the part of the country has to do is implement it properly. See, in Delhi, situation is very different. When bail application, when a charge sheet comes, where the accused who are arraigned as not arrested, courts are granting bail without hearing the arguments. They don't even hear the arguments from either of the side, and they say, all right, since investigating agency has not arrested the accused, why should we send him to jail? Give him bail. First very day. Or maybe in a situation where it says the agency says, okay, I want to file a reply. In that situation, what happens? The Delhi courts give those accused interim bail and send them to home. And then later on next date, maybe bail is granted to him. However, in other part of the country, what I have seen when Mr. Pava and Mr. Dubey was also saying so, that the accused appearing on the first day, they are sent to jail. They are taken to custody rather than they should be rather given interim bail or maybe given a bail with immediately from the court, and the court should rather stress upon the expeditious trial and reach to a logical conclusion rather than punishing the accused during these trial period and keeping them in jail, and especially at least those accused who are not arrested during the investigation. So I believe unless there is some compelling situation, see what happens when when these accused appears before the court understands there are situations when there's likelihood that because of the gravity of offense, these days, financial shenanigans are of high magnitudes.
I have to go to Mr. Mir, but one small question to you before I go to Mr. Mir. When you argue this bail application and the judge rejects it, does he record reasons for the rejection? That why post charge sheet also he thinks it is fit to keep the accused in jail?
No, I'll tell you, that's what I was coming to that aspect, Tarun. What happens unless there is some compelling such situation where a court believes or feels that since the matter is of high magnitude, the financial shenanigans especially, or UAPA matters, these are of high magnitude, very serious offenses. In those cases where court feels that accused may abscond, they may not participate in the course of justice, or they may intimidate witness outside, destroy evidences. So all these situations court takes into consideration, and if that is going against the accused, that there are likelihood that these things may happen, in that case, accused must be sent to detention during the trial.
Thanks for sharing that point. I'll go to Tanveer Ahmed Mir. Whenever you come across such situations when bail is rejected even after filing of charge sheet, what kind of reasons are recorded? Why do you think it is anti-liberty? What Supreme Court judgments would you rely upon? Are the lower courts violating the Supreme Court guidelines? Can you share all of this with us?
Well, thank you, Tarun. You, I think, put about 3 questions in one. But let me first start with first point, where Mr. Bhandari referred to how the bail law is dealt in England and all common law countries, even from United States, New Zealand, Singapore, and Australia. Well, let me tell you that the Indian scenario in bail law, say about after independence and going up to even say about 10 years back, 15 years back, was absolutely the same. In most of the cases, even forget not arresting during the course of investigation. Even otherwise, the bail jurisprudence was same. You would come up and the learned prosecutor would never oppose. Somewhere subsequently, late 90s, early 2000s, there have been very deflecting opinions coming from Supreme Court. For example, one of the public prosecutors' favorite judgments when they come and oppose a bail, post-charge sheet, prior charge sheet, is Pappu Yadav's case, Rajiv Ranjan. Now, invariably what happens is that when you deal with that kind of a case, that kind of an applicant with his kind of a background, whether you can apply to that kind of a situation to all other cases. So there certainly, I would use the word that somewhere the bail law has got obfuscated, and it definitely needs better streamlining. And first of all, the honorable judges of the Supreme Court have to talk in a uniform language as regards bail. Because what happens is we get one judgment on one day, another judgment on another day. And that takes the lower judiciary and high courts, for a absolute tizzy. And then they don't know how to deal with it. So they seek more assistance. It takes more time. There is no gainsaying in the fact that, yes, in criminal trials, the better time has to be spent on trial. You don't have to waste time on bails. And fundamentally, how the bail jurisprudence is getting, violated at the trial court levels, not only in Delhi or in other places during their own jurisdictional problems, is because somewhere, we have forgotten some great examples of bail jurisprudences who are also, now by certain quarters called as liberty champions. For example, in way back, I think, if my memory serves me right, in 1977, Justice Krishna Iyer wrote a judgment called Gudi Kanti Narsimulu. And he started with two words, bail or jail. And then, the discourse started. In that, he referred to Benjamin Cardozo talking about judicial discretion. Now, judicial discretion is something which has sort of, plagued us, and it has also caught our imagination on many occasions. So in words of this great jurist, he said that the judge does not have to yield to, spasmodic sentiments. And judicial discretion has to be exercised on uniformity, positively, and in liberal jurisprudence of bail. That liberal jurisprudence of bail, somewhere, I think we have virtually cannibalized.
Point very well taken.
I'll also tell you what is the problem in other states. About 98% judiciary in Delhi do certainly fundamentally, even before Honorable Justice J.D. Kapoor in 2004 wrote his famous judgment of court on its own motion, which was a suo motu cognizance. And thereafter, there was a reference to a division bench, as my brother, Mr. Dubey, said. The problem in UP and other states is slightly different. It is jurisdictional. It's also conventional. For example, if you go to Ghaziabad District Court and you're summoned by a court of competent jurisdiction there, you appear before the court who has summoned you. The first thing the court says, file a surrender application with your photograph, Aadhaar card, and let your lawyer identify you. The moment you come to his court, and you also get a bail application, he returns the bail application to you. He says, I will not take your bail application. You file your bail application before the district judge. Now, when you file your surrender application and your lawyer identifies you, that court which has summoned you takes you into custody. You are sitting now in the court, in the custody part, and waiting for your fate. Meanwhile, your lawyer goes and files a bail application before the district judge. The district judge sends that bail application at 2 o'clock. At 2 o'clock, when the learned prosecutor appears, he says, I need 7 days time to file a reply. And there you go, straight into custody.
Now, beautifully explained by Mr. Mir. I'll come back to you again.
Tarun, this happens in UP. It happens in Bihar. It happens in Madhya Bharat. It happens in Maharashtra. It happens even in Karnataka. And, somehow it doesn't happen. Haryana is still better and Punjab is better.
Thanks for sharing. It was interesting to hear you, especially the last part where you spoke of Ghaziabad and the procedure. It was good to listen to that. I'll go to Senior Advocate Vikas Pava. When you happen to argue these matters, say in Ranchi, Delhi, other states, are you convinced by the reasons recorded by the learned judge for keeping the accused in jail post filing of charge sheet? If you're not convinced, can you share some of the times when you have felt absolutely dejected because some man who deserves to be out on bail is spending time in jail? Can you share that anecdote with us?
Yeah, certainly, Tarun. I must share a few of my, experiences in that. When I said that the judgments of the Supreme Court, which have recently been passed in August, September, and October, are actually, although the intention was very, very good, the intention of the Honorable Supreme Court was to streamline the law on bail. But the way it is being interpreted by the courts all over the country is a completely different subject now. Now, please take the last judgment of Satyendra Singh Antil's case, where the Honorable Supreme Court has divided all bails into 4 categories, category A, B, C, and D. So A is, if the offenses are less than 7 years, it should be treated as A, where bail should be granted to all without going into the merits of the case. B is with regard to the offenses which are more than 7 years, life and death. And C and D. C is with regard to special statutes, and D is with regard to economic offenses. So this categorization is creating a lot of problem all over the country. The moment you categorize economic offenses as category D and direct, and this is a judgment passed by the Honorable Supreme Court, which has to be followed by all, that please pass orders on merits of the case. So there's a classification which has been done. Now this classification is creating a problem. Now, the moment you go in a case where there are multiple accused persons, it's a case of ED, for instance, or a CBI where it's a multi-crore fraud, So the moment you deal with multi-crore fraud, it creates a burden on the head of the honorable judge. The judge feels that the quantity of money involved, the quantum of money involved is the deciding factor. The moment you say 100 crores, the bail is dismissed on the ground of gravity. Now, bail jurisprudence is completely different, does not talk about gravity of the offense at all. One of the factors is gravity of the offense. But as my friend was talking about Guddi Kantri, one very significant point which I would like to make here is Justice Krishna Iyer in 1978 himself has made a mention that our law on jurisprudence is not clear. It's high time that we should, clarify it. And he says that the subject of bail deals with the blurred area of criminal justice system. He used the word blurred area of criminal justice system. And he says it hinges on the hunch of the bench. So these are the words of Justice Krishna Iyer, hunch of the bench, and which otherwise is called judicial discretion. So judicial discretion, as you rightly pointed out, what are the grounds? The grounds are, it's a discretion of an individual. If an individual feels 100 crore is a very big amount, the bail is rejected. If he feels no, 100 crore is okay, but 1,000 crore is more grievous, then the bail is rejected on 1,000. There is no other reason given in these orders, because these accused persons whose bail are rejected are not wanted for investigation.
It's a very beautiful point, Mr. Pava. This is my takeaway for the show also. Hunch of the bench and discretion, which may or may not have a grounding in law, depends on whether you agree or you don't agree with the order. We are almost out of time.
One line more. The reason for rejection of these bails should be, number one, that he is going to abscond. He will not join the trial. He will abscond. He will run away from the country is one ground. Second, he will tamper with the evidence, or he will threaten with the witnesses, or he is a serial killer or a serial criminal. Now, these are all grounds which were available to the investigating officer when the investigation was being conducted. IO finds that there is no reason for arrest. Why should the court reject the bail? All these grounds are not available.
We will take this up in part 2. These last 3 points which you said. One final comment from Senior Advocate Pramod Dubey before we end the show. Again, only on reasons recorded by the learned judge while rejecting the bail. Have there been times whether you are totally unconvinced with the order? When have those instances happened, and what are your observations in Delhi and outside of Delhi courts?
See, Tarun, there is a triple test. That is the convention, that is the gravity of the offenses, tampering with the evidence, and fleeing from the justice. So far, the fleeing from justice and the flight risk is concerned, the court can easily balance. Court can put the conditions, like he cannot travel abroad without the permission of the court, his passport will be seized. So these kind of the condition can be imposed. The second thing is the tampering of the evidence. We have the Witness Protection Act. So the court can pass the order for the Witness Protection Act if the court thinks so. So by the gravity of the offense, that is not the sole ground for the dismissal of the bail. Because at the time of the investigating agency did not find to arrest the person on the gravity of the offenses. So far the economic offenses is concerned, we are coming every day across the judgment by the prosecution side, that's a Y. Jagan Reddy judgment, which is the economic offenses. And the Supreme Court has said that the economic offenses are spreading like the cancer. See, ultimately, Y. Jagan Reddy got bail. He's the chief minister of the state. He's the chief minister of the state. So what is the purpose of citing this judgment in the today day? Like Pappu Yadav case, they all are out on the bail. You cannot dismiss the bail by citing Y. Jagan Reddy and the Pappu Yadav to dismiss the bail. Ultimately, the person got bail. He's holding the constitutional post as on date. As till date, you are citing the same judgment for the rejection of the bail. Once the investigating agency filing the charging, why the person's personal liberty would be infringed? Because the personal liberty is the jewel of the Constitution, Article 21. If you remove Article 21, I don't think the Constitution would be your in all framework. You are not.
This is a good note to end part 1. We will continue our discussion in part 2. But I must say a very, very informed discussion today, especially when we are looking to double our economy size to 5 trillion. We can't grow if the businessman staying in this country is in a sense holding back money because he knows that there may be some allegation and he'd spend some time.
Tarun, I would like to make one point. In economic offenses, these days we are coming across, most of the economic offenses are the civil commercial dispute. In the most of the cases, basically the criminal color has been given. So you cannot judge the matter on the quantum of the amount. These all are the commercial transactions.
Point well taken. This brings us to end of part 1. I would like to thank Senior Advocate Vikas Pahwa, Senior Advocate Pramod Dubey, Advocate Abhimanyu Bhandari, Advocate Nitesh Rana, Advocate Tanveer Ahmed Mir for sharing their views with us and such strong and good anecdotes and observations that they shared. In part 2, we will continue this discussion and take up some more important issues in the sense which relates to why people are kept in jail post filing of charge sheet. Thank you for joining us.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.